the committees in public session. This meeting has been convened to consider the Legal Services Regulation Bill 2011. No apologies have been received. I would like to welcome the Minister here and his officials to this meeting this morning. Please turn off all mobile phones. Not good enough to have them on silent. Turn them completely off as they interfere with the sound system. It's not fair to the officials to have to listen to the interference. So please turn all mobile phones completely off. And I could ask people in the public gallery to please turn phones completely off as well. I understand, Minister, that you have to be elsewhere at 11 or thereabouts, so can we agree we finish at 11 a.m. Is that?
Yeah, the elsewhere is the Dáil chamber.
Yeah, I know.
And Deputy Collins will be very anxious to follow me over there,
indeed.
I know, at least.
So is 11 a.m.
Yes.
finishing time for everybody?
Sure.
Just to adjourn? Okay. Okay, well now turn to the start working on the bill. Turn to section 1 of the bill. Now, section 1, and the question is that section 1 stand part of the bill. Is that agreed? Agreed. Section 2.
Sorry, Chair, can I just...
sorry, section 1, yeah?
Can I just query in relation to section 1? Can that section be settled substantially today? Like, is there not knock-on issues further out in the bill in relation to commencement dates, which are relevant to section 1, which may get changed further out?
Well, normally when we dispose of a section, we dispose of it. We don't come back to it again. Minister, have you any comment to make on that?
Well, no, I don't envisage we'll be changing section 1. If there, insofar as there are issues relating to other sections, we'll raise them when we get to the other sections.
Okay. Is that all right? Deputy Collins, happy with that?
Yeah.
Right. Yeah. It's always possible to come back to something in the report stage now that you've raised it anyway, if you need to. Okay. So the question is that section 1 stand part of the bill. Is that agreed? Section 2, amendment number 1 in the name of the Minister. The question is that the amendment be made. Minister to move, sorry.
Yes, I move, Chairman. This is just a minor technical amendment to correct a typographical error in the published bill.
Question is that the amendment be made. Is that agreed?
Agreed.
Agreed. Amendment number 2 in the name of the Minister. 2 and 4 are related and will be discussed together. Get the Minister to move amendment number 2.
I so move. The purpose of amendments number 2 and 4 is to broaden slightly the definition of lay person. The current definition in the bill is very limiting. It states that a lay person is someone who is not and never has been a practicing solicitor or barrister. However, I am proposing, for example, that the Institute of Legal Cost Accountants nominate a lay person to the authority under Section 8 due to the relevant expertise their nominee is likely to bring. It's not impossible that such a nominee might previously have been a practicing lawyer. Therefore, the amendments I am proposing here will allow for formally practicing but currently non-practicing barristers and solicitors of 5 years to be considered for nomination as a lay person. While it will be essential to ensure that the authority will not suffer from regulatory capture by the legal professions, I do not think it unreasonable to allow some scope for persons who have legal experience in the past but no real or ongoing affiliation with the professions to be nominated as lay persons where they have additional expertise. I expect there will be other amendments to the interpretation and construction section of the bill at report stage when certain other aspects of the bill are settled, but they are, Chairman, for another day.
Okay. Deputy Collins?
Yeah. Can I just ask, I want to tease this out a little bit more, if you don't mind. Am I right in saying we still don't have an impact assessment, regulatory impact assessment in relation to this bill? That's the first point maybe we can address. And in relation to amendment number 4, what you're essentially couching it in my own terms, you're introducing, I suppose, what we could term as a cooling off period of 5 years for former members of the profession to be then deemed as laypersons. What's the basis of 5 years? What's the rationale in relation to 5 years? I mean, a person could be involved. Is there an industry or a national standard for cooling off periods? What experience or what has informed this decision in relation to it?
Well, let's take the last question first. No, there isn't a national standard for cooling off periods. I suppose for some people who cease to be politicians. There's never a cooling off period, I don't know. People have engagements in different professions, but there are certainly people who in their lives might at some stage be a practicing barrister or solicitor who engaged in other areas of life, and indeed you could have, for example, a legal cost accountant who in a former life was a practicing member of the legal profession but hasn't been a practicing lawyer for many years. So what I didn't want to do was entirely close off people who clearly weren't practicing barristers or solicitors from a possibility of an appointment. The 5 years isn't a magical number. It was just looking from a common sense perspective on what would be an appropriate period of years during which somebody didn't practice. I've no particular emotional or theological attachment to 5 years, and what this engagement gives us an opportunity to is reflect on that. The suggestion is it be 5 years. That's the amendment we're now making. I have no difficulty with members giving further thought to that if they believe the period should be longer. I don't think it should be shorter. I think there would have to clearly be a gap between someone being a practicing lawyer and assuming the possible status as a lay person. But I'm happy to say, Chairman, that if members of the committee, when we come back at report stage, members of the Oireachtas have a cogent argument as to why it should be a somewhat longer period, I'd be very happy to listen to that. But this seemed a practical number of years. I think in the context of former civil servants or secretaries general in various departments, there's now a rule or an ethical standard that suggests for a period of time, and I can't recall whether it's 2 years or whether it's 1 year, but I think certainly for a period of time that you don't take up a position that would be in conflict with your former life. And there's certainly some new provisions in relation to ministers. But I'm happy if Deputy Collins has a different view. I'm happy to engage on that issue. Just
on that point before you move off it, and it's not under our area of responsibility, but there's legislation being discussed, and I attended a conference to registration of lobbyist bill, and there's talk of cooling off periods, and it's 2 years. I just think 5 years is. Now you're indicating that you're only prepared to accept greater than 5 years with an argument to substantiate it, but 5 years seems. And you haven't given a reason why. You've just said you picked 5 years. You haven't given a rationale, really. But anyway, okay.
The reason is to ensure someone does, from a public perspective, clearly fit the category of being a lay person. I think if you're talking about a body that is designed to be independent, where there's an architecture in which there's a certain representation from the legal professions and there's a specific number of lay people, under the guise of someone being a lay person, we don't want it, as I said earlier, to become really top-heavy with lawyers and undermine the balance that we've tried to provide. So 5 years provides a period of time in which I think somebody would be substantially disconnected from their former life, and you would have the lay-lawyer balance. That's why I'd be reluctant to reduce the period. I think it would be an issue of increasing the period if members thought that would be appropriate. And this is, you have to remember, a regulatory body for the two professions, and there is a particular balance we're trying to maintain. On the first question that Deputy Collins raised, a regulatory impact assessment for the Legal Services Regulation Bill will be made available in advance of the resumption of committee stage after the summer recess. The issue of the regulatory impact assessment at that time will enable it to take account of the development of the bill since its initial publication in 2011 and right up to this autumn. Work on the bill will continue over the summer, and I will, upon the resumption of committee stage, be tabling a series of important amendments in relation to the remainder of the bill, and we want to factor into that the regulatory impact assessment oversight, which I think is important. I think this approach is best to ensure that the regulatory impact assessment is concurrent with the actual progress and the contents of the bill as amended or as proposed to be amended, rather than simply out of kilter with its development and being based on the bill as published. I think doing it this way also shows some respect for the very interesting and varied submissions we've received and for what we propose to take on board, and I hope approaching the matter in this way will also facilitate members of the committee in the further deliberations we have at committee stage. The alternative would have been to have produced an assessment on the bill as published, and we've gone, I think, substantially past that point. I think this is a better way now of dealing with this. There's still work being undertaken in amendments that haven't been finalised, and I want what we do to reflect that so members of the committee will understand not simply where the bill started from, but where we hope to take it and the backdrop to some of the amendments that are being proposed. So I hope that actually proves helpful to the committee as opposed to otherwise. In the context of what we're dealing with today, it's substantially without going into the generality of it, dealing with a variety of issues, and in which I think there's a united view on the changes to be made. It may not be that the exact changes are specifically agreed, but I've always been of the view, despite all the controversy generated, that it's very important that there's no doubt about, for example, the independence of the Legal Services Regulatory Authority. So insofar, and it certainly was never my intention as Minister to be engaged in its day-to-day work or interfering with it, but insofar as people had concerns about that, essentially they're the amendments we're dealing with today, and they seemed to be relatively straightforward in their intent in copper fastening the independence issue. Without having to produce a regulatory impact assessment prematurely to include that when there's still work being done on the later sections.
So we won't get very far today.
No, but this is an important point because it's a challenge for all of us because of the time squeeze and when the amendments have been made available to us, and in terms of carrying out a proper regulatory impact assessment. I presume, what's your timeline in terms of publishing the remainder of your amendments across the rest of the parts of the bill? Because it's a challenge for us over here to participate meaningfully, and for others out there who will want to make submissions to you and to your department on foot of the amendments when they're published. So where are we with the rest of them? Because it's not best practice, I suppose, just publishing them in a short a period as the first group of amendments have been published. I think you can't disagree with that.
Well, I'm sure the Deputy is aware, and over 14 years his party has been government when I was in opposition, it was quite usual that amendments proposed to bills would appear about 4 days max before a committee stage started. There was absolutely nothing unusual about that, and unfortunately, in the context of the pressure of work involved between departments and the Attorney's Office, it's often not possible to do it differently. In the context of where we are at the moment, there's ongoing work being done on the amendments. The work will continue during the summer. I can't at the moment give a definitive time frame, but I would hope that before we restart on committee, that members will have at least a week to see amendments in advance of the committee sitting. But of course, Chairman, we always have to remember that committee stage is one part of the process. We come back on report stage, and if people feel that there are amendments not adequately teased out or they don't have time to tease them out, we always have an opportunity to revisit issues on report stage. But I don't want to constrain it beyond that, because having been in this House for many years, it has been rare that you would have committee stage amendments published weeks in advance of committee stage. It's not because I want to be unhelpful, it's simply because of the demands and constraints on the Attorney's Office means I can't give a definitive date as to when particular amendments will be made available to me, but I would hope that we'll have a clearer view as to exactly where we are very early in September, and that should
just a key point, and it's a final point. Just a key point.
1 minute, please. Hold it, please, one moment.
Yeah.
I'm anxious not to get into a
I understand.
Would you please hear me out?